matter before the court is Cumberland 23-329, Mark Cardilli versus State of Maine. We are being streamed live on the web, both by video and by audio. I would ask counsel, before we begin, to identify yourselves by saying your names for the record, together with the party you represent, starting with the appellant.
Leanne Robbin for the State of Maine.
Attorney Thomas Hallett for Mark Cardilli.
Thank you. And Attorney Robbin, I understand you are prepared to proceed. We'd be happy to hear your argument.
Thank you, Your Honor. Chief Justice Stanfield, Associate Justices, may it please the court. During the bench trial in December 2019, the court heard evidence that Mark Cardilli Jr. intentionally and knowingly shot his sister's unarmed boyfriend, Isahak Muse, twice in the back at contact range. Because Isahak, a frequent visitor at the household, had overstayed his welcome. A bullet defect in the floor indicated that Isahak had been bent over or prone when he was shot in the back. But as a result of trial counsel's vigorous defense, the court acquitted Cardilli of murder, finding that while Mr. Cardilli believed that Isahak was an intruder and that deadly force was necessary to defend himself or his family from bodily injury, the state had proven beyond a reasonable doubt that both beliefs were unreasonable. The court expressly concluded that deadly force was not necessary to prevent minimal bodily injury or to remove Mr. Muse from the house, and instead convicted him of manslaughter. On post-conviction, Mr. Cardilli argues that wasn't good enough. He argues that a single line in trial counsel's closing memorandum, arguably waiving self-defense based on his belief that Isahak was about to use deadly force on Cardilli or his family members, possibly affected the outcome of the trial. It is that single line that caused the post-conviction justice to question, quote, the integrity of the trial process based on the justice's, quote, own trepidation that the written closing argument might have affected its own fact-finding judgment. Despite this court's previous ruling on direct appeal that the trial court's detailed and extensive factual findings precluded a defense under 108(2)A. As for the post-conviction court's concerns that the purported waiver might have affected the trial court's fact-finding process, the trial justice found most key facts against the state. The court rejected the chief medical examiner's measurement of the victim and instead concluded that Isahak was significantly taller and heavier than Mr. Cardilli and his father. It rejected the conclusion of the evidence technician with over 16 years of crime scene experience that the defect on the floor under Isahak was from a bullet. And it found that Mr. Cardilli himself was credible, even though he repeatedly claimed to have been facing Isahak from a distance when he shot him, a claim contradicted by the 2 contact gunshot wounds in his back. Speculation by the post-conviction justice that he might have decided the case differently is no basis to overturn this conviction. The burden was on Mark Cardilli Jr. to show that his counsel's purported error caused prejudice, and he failed to do so in that case. I'd be happy to take questions.
Counsel, you seem to spend a fair amount of time undermining or trying to undermine the findings of the trial court, but those findings in terms of an acquittal of murder and conviction of manslaughter are not at issue here. You also indicated a few times you called it arguably waiving self-defense under 108(2)A or purported waiver. There's no question that there's an explicit waiver in the brief. I understand that there may have been some other things to the contrary, but there's no question that there's an explicit waiver in the brief, is there?
There's an explicit waiver in the brief.
Okay. And are you, on appeal, you are focusing on the PCR court's finding of the prejudice prong as opposed to whether or not there was ineffective assistance in the way that there was coordination or whether there should have been a waiver. Am I right on that?
That's correct, Your Honor.
Okay. And so we can focus simply on that, whether, does that come down to whether Justice Mills, the trial court's findings are already sufficient to essentially negate the self-defense that was waived?
That's correct, Your Honor. As this court concluded, that her detailed factual findings precluded the finding that Mark Cardilli Jr. reasonably believed that Isahak was about to use unlawful deadly force. And her findings that deadly force was unnecessary even to repel minimal bodily injury subsumes the conclusion that it would have been that it would have been necessary to prevent serious bodily injury. She did not need to specifically address 108-2A because those findings were necessarily included in
Is that
her
a
analysis.
factual finding, though, on the part of the PCR court that we should defer to?
No, Your Honor, I believe that it's that the ultimate conclusion about whether or not the ultimate conclusion as to whether or not there was justification in this case is a legal determination based on the factual findings.
Is it problematic that the two lawyers here they're not on the same page? They had approaches that were not cohesive or consistent. And the argument, as I take it, is that because Attorney A took this approach, Attorney B took this one, and Attorney B's approach might tend to undercut the approach the other one took. I'll ask you first, if that is the case, just the four corners of that, does that justify the PCR court stepping in, the fact that the counsel are on different pages?
No, Your Honor, not in our view. In the heat of battle in a trial, there can be different approaches and different arguments made by co-counsel. I've certainly had that on the prosecution side as well as seen it on the defense.
Now the defendant here is pointing out to the fact that a statement made by Cardilli that he didn't know if he could take another punch is at the heart of this, and depending upon the weight or the importance we place on that might swing the difference here. We have the benefit here of the trial court took an extra step and said, well, even if, and proceeded to do the analysis there. But that's where the clash takes place. Was the court affected by the fact that this particular defense wasn't approached and the fact that Cardilli says, I couldn't take one more punch? Does that undermine the court's ultimate conclusion that his belief was objectively unreasonable?
No, Your Honor, I don't believe it does. This is not like a jury trial where jurors are only given options A and B. We, in fact, in our argument, in the closing argument, had laid out the 102A and 108-2A and 108-2B arguments under imperfect self-defense. And I am confident that Justice Mills listened to the entire legal framework and made her determination, regardless of what the legal arguments were made by counsel. That there's no argument that she dove into this case, looked at the record, and produced an over 50-page decision with detailed factual findings, and then dove into it again to respond to a motion to reconsider her decision. All of the law and all the facts were before her, and this case would be different if post-conviction counsel could have pointed out to a fact or facts that could have been presented that wasn't presented. That wasn't done here. Every fact that post-conviction counsel has pointed out supports his legal argument was in fact presented and vigorously argued by Attorney Nichols.
Well,
in his
at the
oral closing.
PCR hearing, didn't the trial counsel testify being killed by a punch? The answer to that was repeatedly negative. He feared only being killed if the victim took his gun. And that's the four corners of Attorney A's recollection and approach to the case. Right.
And in fact, that was the statements of Mr. Cardilli himself from the moment he spoke with law enforcement. It appears that Mr. Cardilli thought because Isahak Muse was in his house, he had a right to shoot him when he wouldn't leave.
But he did say, I didn't know if I could take one more punch.
He did say that. I believe that may have been in the walkthrough as opposed to the initial interview with Detective Giesecke at the police station. His story did evolve as he had time and legal counsel.
Justice Mills, in her order on the motion to reconsider, this is page 196 of the opinion, said defendant, and I quote, defendant, meaning Mr. Cardilli, introduced the only deadly force to the situation, end of quote. What does that tell us about whether a section 108A2 defense would have been viable had it been pursued?
It's pretty clear from her decision that she had rejected that Isahak was about to use imminent deadly force, or that Mr. Cardilli, even if he believed it, that belief was reasonable, that he was about to use imminent deadly force. Mr. Cardilli walked by his cell phone and a charger, went to his gun safe, unlocked the gun safe and loaded the gun and brought it down to a pushing match. He's the only one, as Justice Mills said, he was the only one who brought deadly force into the situation.
Well, the PCR court seemed to say that the reference in the direct appeal that it appeared from the findings of the trial court that he couldn't win the prejudice issue. The PCR court said, I don't have to meet that because I find it undermines the integrity of the proceedings. In what circumstances should there be an integrity of the proceedings, a finding of ineffective assistance, when the fact finding shows that you couldn't prevail?
That's been the state's position, that the facts in this case do not support a 108-2A defense, and there are no facts that post-conviction counsel have pointed out to that were not presented, that could have been presented, that could have changed the result here. So the outcome seems like it would not only might it have been different, it wouldn't have been different. That this court has already looked at these facts and determined that on these facts, and there are no more facts, that there is not that there was not a reasonable belief, there could not be a reasonable belief that Isahak.
But are we then assuming that essentially the trial court placed no weight, none, on the written closing? Because the written closing expressly did say that it was going to waive the self-defense under 108-2A. And it seems to me that what the PCR court is saying is that given that, there's a reasonable probability that the facts would have been found differently had they been framed, if you will, to the trial court correctly.
And that's why we went through the facts, which I think Your Honor took a little exception to, the facts that showed that we don't see any facts that could have been decided differently that would have ultimately supported a different outcome here. That all the facts, there was nothing wrong with the fact-finding process, and certainly that the trial justice didn't take the state's version of the facts as true, and the statement in the closing memo was, this is not a case under 108-2A where there was a use of imminent deadly force. The trial justice was certainly free to accept or reject that legal statement, and in fact made her own analysis of the facts and decided that there was no reason to use deadly force here.
Thank you. Mr. Hallett.
Yes, thank you. Chief Justice Stanfill, Justices, may it please the Court. The issue, as I understand it, is the state's challenge here is to establish that the post-conviction review court, that there's no competent evidence in the record to support the finding of the post-conviction review court. That is the standard set forth, identified, and has been the standard for some time, and specifically articulated in Fondley v. State. As in Fondley v. State, which interesting was a Justice Mills case where she found that that post-conviction review was appropriate and ineffective assistance had been found in that case, there is a decision for this court to look at. And it's a well-articulated decision by Justice O'Neill laying out the facts which support his position. It is Mr. Cardilli's position that the facts that are laid out meet the challenge of establishing competent evidence. There is no question but that the two lawyers had inconsistent theories of the defense in a murder case. By any measure, that does not meet the standard that is applicable for prevailing professional norms or the ordinary fallible attorney. We cannot accept that that meets that standard. We cannot accept that a closing written argument which withdraws a very substantial defense which has been established during the trial, and I don't dispute that. The facts were laid, the groundwork was laid. We cannot accept that when you withdraw that defense, that does not meet the first prong or the performance prong of the ineffective assistance test. There is ample evidence to show that the performance was below the necessary standard. The question then becomes, what is the prejudice test?
Counsel, I see.
Yes, ma'am.
Green light is on. Can I return to something you started off with? That there was about the evidence supporting the conclusion of the PCR judge. But in the end, the conclusion that whether the counsel's error, and they don't seem to be contesting that there was one, or at least not on this appeal, I know they did vigorously below, but that counsel's error had an adverse effect. Isn't that really a legal conclusion? He's not basing that really on any evidence other than, gee, it feels like if the trial court had realized they shouldn't have waived this, they might have reached the trial court might have reached a different conclusion. But isn't that really a legal conclusion on the part of the PCR court that would be subject to a de novo review rather than a factual finding for clear error?
Well, there's certainly a legal component to any finding of ineffective assistance, but whether there's prejudice or not, I think, is a factual determination also.
But what are the facts that are contested, essentially, that the judge had to find in order to reach the conclusion that there was an adverse effect?
The most significant fact is that the judge looked at the written waiver withdrawal, however you want to put it, argument against a 1082A defense, which was submitted by the defense counsel.
And you described that earlier in your comments here as counsel withdrew, and you said a very substantial defense.
Yes.
Those are your words.
Yes.
And the defense was that person justified using deadly force, and he reasonably believes that the other person is about to use unlawful deadly force against the person.
Yes.
But we have the trial court expressly saying, no, that the victim here was not about to use deadly force. The only way the victim would get access to deadly force would be if he dropped the gun on the floor, and he took the gun and used it against Cardilli. So it's hard to characterize. I don't get your characterization of a very substantial defense.
With all due respect, when I say substantial defense, I believe that had counsel properly analyzed this case and presented this case, that the 1082A defense would have been the primary defense. It was laid out in spades when, on redirect.
But you can say that as a legal matter, but that didn't change the facts, did it? I mean, the facts were fully laid out in the trial and again in the PCR. They're no different. It's not like there are new facts introduced.
Well, I don't think that's entirely accurate. I think the primary fact, and this is it, the reason why I shot was I feared not knowing how many more punches I could take. And if I dropped the gun, lost the gun, Mr. Muse would take it and turn it on me and my family. That was articulated on a redirect question at the end of Mr. Cardilli's testimony, after Mr. Cardilli was asked, you didn't fear for your life, this is, and I'm paraphrasing Leanne when she asked that question, he said, yes, I did. And then on redirect, that was articulated. For the very first time that was articulated, that should have been the hallmark of the case. That says, I feared for my life. I feared that if I dropped the gun, if I was hit one more time, then the gun would have been picked up and I would have shot, he would have shot my family members or me.
So are you faulting the way trial counsel handled the case as to the evidence that went on? Or I thought the fault here was that one of the attorneys pulled the plug on that defense with that memorandum.
Our post-conviction review petition clearly articulated that we believed that the defense had not been presented. That's what we were saying. The defense was not presented, and it was specifically not presented in the written memorandum. But on questioning, Mr. Nichols said, no, I did present that defense. Now, it's nowhere articulated in his closing that there's a 108(2)A defense. Nowhere. He says that he rightfully feared for his life, but he did not articulate it. And our expert, Ms. Johnson, a professor at Rutgers, said, you know, this needed to be a full-throated defense.
But I'm going to stop
Yes.
you, because yes, we all understand that, and that the PCR court found that it wasn't articulated, that it
Yeah.
wasn't given the full-throated emphasis that it needed to be given. But it doesn't change the facts, does it?
Yes, it does. It changes everything, because it changes the view that is taken. Justice Mills did not analyze a 108(2)A defense.
Well, she said his belief to that effect was obviously unreasonable.
But he didn't analyze it specifically. She wasn't called upon to address that issue, right? And as Justice O'Neill points
But she
out,
wasn't called upon to address it as a legal matter, as in citing the statute, but didn't she in fact address it as a factual matter?
I don't think so, no. I think to address it as a factual matter, she would have to look at it through the lens of, I am saying, okay, what exactly happened from this 108(2)A perspective that was not done. The reason it wasn't done was because the whole thing was contaminated.
Excuse me. She said that Mr. Cardilli brought the only introduced, this is the quote I read to Ms. Robbin, Mr. Cardilli introduced the only deadly force to the situation, page 196 of the opinion. And then in her findings, she said, defendant, Mr. Cardilli, knew that Mr. Muse had no gun, didn't see him with a knife. Mr. Muse did not try to grab the gun. How is it possible that a defense that would have required the state to overcome a showing that Mr. Cardilli reasonably believed it necessary that Mr. Muse was about to use unlawful deadly force? Her findings eliminate any possibility that Mr. Muse was about to use unlawful deadly force.
I would submit that a fact finder could find, based exclusively on the statement made on redirect, that I didn't know how many more punches I could take, and I was afraid that I would lose my gun and that he would shoot myself or my family, and that would satisfy the question as to whether deadly force was about to be used.
Well, she acknowledged that he made that statement.
This court didn't, however. This court specifically said he didn't make a statement like that in its summary of the facts when you said, in any event, so I just would point that out.
Justice Mills's findings say that the defendant was concerned that if he dropped the gun, Mr. Muse could use it against defendant and his family. But she later found that if he believed that he was at risk of having deadly force used against him, that belief was not reasonable.
Yeah, on page 191, she expressly says that his belief to the effect that deadly force was necessary to prevent bodily injury to himself or anyone else was objectively unreasonable.
Okay. And I would say the reason for that is because Mr. Cardilli's counsel said, don't believe my client. If he tells you that he feared for his life, don't believe it. Because we don't have that defense here. That is not a defense that we can use. I've been with him for a year. I know exactly what he says. I know exactly what happened, and I'm telling you that's not a defense that applies in this case. That contaminates every thought process that goes on in this case. And I think that's what Justice O'Neill is saying. That if you take a view that your own lawyer undercuts your most significant defense, that contaminates any findings by the court. And I believe that that's the basis, really, for his prejudice finding, is to say, you cannot view it through that prism. The judge viewed it through a wrong lens, viewed it through a structural defect in the integrity of the system, because the lawyers did not do their job in this specific case. And that, I think, is the crux of this case. When you view it through one prism, you get one result. When you view it through the other, and I would suggest that the 108(2) defense was the only defense in this case. The other defenses were very difficult defenses.
But what you're suggesting is that if trial counsel's performance is substandard, in other words, falls below the ordinary fallible attorney standard, that sort of eliminates the issue of prejudice. We don't need to talk about prejudice because the substandard performance contaminated the process.
I don't agree with that.
Well, what distinguishes this then from any other case? In other words, if what Justice Horton is saying is, you essentially seem to be saying, well, because they presented it poorly, it fell below the standard of an ordinary fallible attorney, we have to assume it colored the lens, the fact finding.
This is a case where there is a failure to present, right? And Justice O'Neill analogizes it to the civil case. When you are ineffective or you don't meet the necessary standards and you don't present something, that is a very different animal. And in the Fondley case, that was done also. Didn't present a certain defense.
But what wasn't presented was the legal argument as opposed to the evidence.
What wasn't?
And isn't that different?
Yes, but the view, it changes the entire view of the case. I don't know how to put it another way. When you don't present a proper defense, and that defense should have been addressed by the court, needed to be addressed by the court, the state needed to prove beyond a reasonable doubt that that defense was not appropriate and that it didn't meet the requirements. That wasn't done here. And so it contaminates the entire proceeding, and that fact that it wasn't presented is a factual determination that was made by the court, and based on that fact, and based on the fact that the other evidence wasn't sufficiently emphasized, that the attorneys not only failed to meet their necessary standard, but also caused prejudice in this case. So there were factual issues found by Justice O'Neill, which leads to his decision. They are articulated in his decision. I think if you look at this strictly...
So we have to say to Justice Mills, this particular argument wasn't made expressly, but you went ahead and you analyzed it as if it was, but you were so contaminated by the fact that they didn't raise it that you just screwed up, Justice Mills.
I would say she didn't analyze it. She specifically did not analyze it. Now, she analyzed other things. You know, she made a finding that there was a minimal bodily, that there was no bodily injury, right? That was one of the issues, was in a 108(2)B defense, is there bodily injury? And she basically said there's no bodily injury. There was bodily injury. We all know that. Getting hit in the head creates bodily injury. There was scratches, bloody nose, et cetera, et cetera. I think the findings can get contaminated. I won't go further than that.
Thank you.
Thank you.
Ms. Robbin.
The ultimate determination of whether prejudice resulted is a legal determination, which this court is in a position to make. Given
Well, it is kind of mixed, isn't it?
Pardon?
It is kind of a mixed question.
It is mixed. But the factual, none of the facts are in dispute here. They're all The facts as found by Justice Mills are, there's nothing there's no fact that wasn't presented to Justice Mills for her to consider, and having rejected self-defense under 108(2)B, she necessarily rejected it under 108(2)A. I'd be happy to take any questions that may have been generated by counsel's argument, or I can sit down.
There don't appear to
Thank you.
be any. Thank you.
Thank you.
Thank you, counsel. As is our usual practice, we will be taking this matter under advisement, considering it, and issuing our own written decision in due course. And with that, we are in recess for the day.
All rise. All persons